Welcome to the Book People. I'm your host Aishwarya Javalgekar, a writer, a book editor, podcast producer, and the head of originals at Bound. In this path-breaking video podcast, I demystify the publishing and creative industries and uncover the biggest opportunities and challenges for writers in India today. So, the topic that I'm covering today is something that writers have been worried about since the beginning of time. Whether you're writing a book, or you're writing a screenplay, or you're writing for audio, question that writers and creators always have is how can they safeguard their ideas and their work? And when can you safeguard it, right? Can you safeguard it at the idea level? What exactly can you copyright? And if someone does steal a part of your work, what can you really do about it? So, to answer all of these questions, I am talking to a lawyer this time. His name is Sushrut Desai. He specializes in intellectual property rights and he was a consultant for the Screenwriters Association in India. So, my conversation with him actually was so jam packed with insights that we've decided to put the conversation out in two parts. So, there's going to be two episodes. This is part one, where we talk about what exactly copyright means, what kind of rights do you have as a writer, and what kind of red flags should you be looking for when you're signing all these contracts and agreements with companies and with creators today. So definitely check it out. And stay tuned for part 2, where we discuss how copyright works in music and video and theater, how the law needs to change and catch up to all of these developments with AI. And I also ask Sushrut some crowdsourced questions from the Bound community that we get the answers. So watch out for that. But for now, let's dive in. Today is a very special session because today I'm doing something completely new for the book people as well. I'm talking to Sushrut Desai, who is an IP lawyer. I mean, he does a lot of other things, but specifically, I want to understand, how IP works, how copyright works, and what is the opportunity with these things. So my first question is, I think the basic one that we all need to know. One is, what does an IP lawyer even do? What does it mean? And how did you become an IP lawyer?
I graduated from Government Law College 2008. I am basically a litigator. My job is to draft suits or defense suits and argue them in the High Court, because in only the High Court has jurisdiction under the Copyright Act. So all our cases go before the High Court. So that's where I come in. When the contract goes wrong and some disputes arise, that's when I enter into the picture, basically.
Okay, so you're basically not involved when the initial contract is drafted. Only when there is an issue, you kind of come in.
So what's happened is, over the years, because of my litigation experience, there have been people who've been sort of coming to seek advice before things go wrong at the contract stage, therefore.
Yeah, I would imagine that's when people would want the advice.
Yeah.
They don't want things to go wrong.
Exactly. And I've had the benefit of working very closely with the Screenwriters Association from a pretty junior sort of stage in my career till now. And that's been an association that's got me very deep into writers' rights and also copyright law in general, especially when this has been a pretty transformational time for copyright law because of the amendments and all, but we'll come to that later.
Okay. So, how often do you have to go to court on a day-to-day basis? What do you sort of do?
So our High Court works from 10:30 to 4:30. And a lot of that time we are in that building. We're not always arguing and on our legs, we call it. We're not always on our legs. So, but whenever you have to be ready when a matter is called out to be able to go there and argue. And before 10:30 and after 4:30 is when we do our drafting, meeting clients, advising them, reading our papers, preparing for the next day, things like that.
Okay. Can we go into, what does IP actually mean? Like, what is IP? What is copyright? What is, what are the differences between them specifically? And what can be copyrighted?
Right. So IP is a catch-all term. It's an umbrella term. Stands for intellectual property. And the best way to understand it, and the way we were taught in law school, is by something known as the apples analogy or the apples fallacy, where basically an apple is a property, right? It's a physical thing. Now, if I give you an apple, I have one less apple. But this is not true of intellectual property. If I write a book and I give it to you, I still have the book, but you also have it. So in that sense, intellectual property is distinguished from physical property. And you had a whole bunch of laws that came about to try and protect this category of property. And this category of property is divided broadly into patents, trademarks, and copyright. And copyright is basically your right to any artistic work that you have created. This could be a work in writing, it could be a musical piece, it could be a movie, it could be a poem, it could be lyrics, it could be a software program, because a software program also has to be written. So anything that is written or anything that is created artistically and is unique and has never existed before can be copyrighted. And in fact, I wouldn't say can be, I would say is copyrighted, because unlike trademark and patent, you don't have to do anything extra to protect a copyright. If I write something original, it is automatically copyrighted by the fact that I have written it. I don't have to go and register it somewhere else in order to get that protection. So that's what that is.
And at what stage does something become copyrightable? You know, like for example, if you're looking at a book. So if I just have the idea of a book, or I have a pitch with, you know, some rough outline, is that something that is copyrightable? Or is it, you know, a manuscript? Say I have a finished manuscript of a book. Is at that stage, you know, something that I can copyright? Or only after, say, it becomes a physical book, you know, with a book cover and something that is a product as a whole and can be sold. Is it only copyrightable at that stage?
Right. That's a great question, actually. And the last thing that you mentioned, that when it actually becomes a book, is the moment that is known in copyright law as the moment of publishing. When you publish something and the work becomes public, that is when the whole world is put to notice that you are the owner and holder of this copyrighted original work. But that does not mean that your earlier drafts, which you might have shared with your publisher or your producer, are not copyrighted. They are also equally copyrighted. The moment of protection comes at the time of creation of this document. So in the olden days, what screenplay writers used to do before we had the registry at the Screenwriters Association, what writers would do is they would take their script that they've written, put it in an envelope, go to the post office and mail it to themselves. So what would happen is they would get a stamp that would prove that on this day, this document existed. So, so that in the future, if there is a dispute, if somebody else says that they have a script that is similar, for example, you can open this envelope, show it to court and say, see, this is a sealed envelope, this is a postage stamp, and this is a document inside it.
Yeah, now we do the same thing on the registry. And I think now also maybe, you know, because we use Microsoft Word, or we use these kind of software that also track when changes were made, right? Or when a document was saved. Does that also help as proof in terms of?
Absolutely, because what you have to understand about copyright is, okay, take a situation where two things are extremely similar and they come to a court and the question is who owns it. And if they are so similar as to cross that threshold of copyright infringement, it's a very high threshold, but let's assume for the sake of argument that these two do cross that threshold. What the court will look at is which one came into existence first. And that becomes a very, very powerful indicator of who the original author of the document is. And that's pretty much what it boils down to in a lot of cases. So in the example that you just gave of a Microsoft Word document, certainly if you can prove electronically in a way that cannot be tampered with that you created this document on a certain day, it's absolute proof. That's why people email documents to themselves now.
Yeah, that's true. But that's so interesting because, you know, say ideas are not copyrightable, right? Like if I just have an idea saying I'll write this book or I'll create this podcast, that's not something I can copyright because anyone could have come up with the idea. But that's so interesting about the creative process because say two people came up with the same idea for a book or a screenplay or a podcast, you know, say, you know, it's me and you, and I came up with the idea 1 year before you did, but you wrote the screenplay or you finished the book, you know, 2 months before me.
Yeah.
So then that's something that you can copyright, or like by copyright law, that's something
Yeah.
which would put you as the owner
Correct.
rather than me, right?
There's this expression in copyright law that says that you cannot copyright and that an idea is not capable of protection, only the expression of that idea is capable of protection. Now, what that means is that I may have an idea of a boy meets girl story where the parents are in opposition to it, and then in the end they run away together and then they have to kill themselves. Now, this is a story that has been told 1,000 times in history.
Yeah.
Right? So this idea, if it was protectable, then after Shakespeare, nobody would have been able to do it, or probably even before that. Maybe Shakespeare would not have been able to do it. But therefore, if you only change a few things about this idea and give it a unique expression by setting it with unique populating it with unique characters, setting it in a unique setting or a timeline, explore new themes, and you make it original enough, you will get copyright on it. In fact, this is something that we've seen so many times with authors who have sometimes an overestimation of how unique their idea is. And I always tell them this thing. We had one author who came up to us. He wanted to file a suit because he'd written a script about a dog who is the favorite dog of a wealthy man who passes away. And then his family has 20 days to win over the dog. And whoever the dog likes the most after 20 days will get his entire fortune. And he was convinced this is an extremely unique idea. And he was horrified that that some other person he knew was writing it. So
Right.
I told him, and this is what I tell all my clients, and we use this in court. There's a website called tvtropes.com. So anytime you think you have an original idea, please go to tvtropes.com and put your idea in there. And you will get category wise how many other ideas have the same thing. So when we put this dog inherits fortune, we got about 30 novels, 40 films, 30 manga anime series, and like just unbelievable amount of material. So ideas
Really,
are not
there are that many?
yeah, absolutely. Globally.
Okay, not just in the English language as well,
Yeah, not
or
just
just in the English.
because copyright is universal. Unlike a trademark, which is only for the territory in which you register it, a copyright is universal. When J.K. Rowling wrote Harry Potter in England, you couldn't suddenly copy and write Harry Potter in India and publish it because her copyright is protected even in India.
Right. No, that makes a lot of sense. And when you said that there's this threshold, where for two things to be considered very similar or almost as copyright infringement, what is that threshold that is so high? Like, how similar do they have to be?
They have to be extremely similar. So in the example that I just gave you of this TV tropes, clearly the threshold of dog inherits fortune and family members have to win him over is not unique enough. Because and that is evident from a cursory glance at how many other materials have been written of a similar nature. So now whoever this writer is who's saying that you have copied my dog inherits millions idea has to not stop at that. He has to list down 10 other similarities. Maybe the characters are the same. Maybe the resolution is the same. The climax is the same. Maybe the midpoint is the same. Maybe the twist is the same. And maybe that twist is unique and not found in any of the other places on that TV tropes page, but is found in this. So you have to show very direct links because it is an incredibly high threshold. Like people think that they can get away with pointing out a few similarities. That is not it at all. Okay, I'll give you a situation that happens quite commonly. Yes. A writer writes something. The producer says, I don't like it. Writer walks away disappointed. The producer goes to a cheaper writer and tells him, here's the script, thoda do teen cheez badal ke bana dena.
Yes, exactly.
This happens. So then this first writer will come and say that you stole the idea from me and you've done copyright infringement. But now this writer and producer are no fools. They've been in business for a long time and they know how many things they have to change in order to not meet this high threshold of copyright infringement. Ladke ko ladki bana do, Dilli ko Bombay bana do. And instead of the girl dying, the boy dies. I mean, there's 1,000 tricks like this, and they're not even that complicated. And what that does is it creates a product that you can arguably say is different, arguably. And then the first writer who tries to stop this film from coming out, saying this was my idea. Well, so basically you go to court asking for an injunction that don't release this movie because it's mine. It's my intellectual property. So that's called the interim stage. So at that interim stage, the judge will say, I don't know, it looks like there's about 10, 15 things that are different. So I don't think I can give you an injunction. Now, what this writer could have done different, which is what we advise all our clients to do, is to forget about copyright infringement as a concept. Don't even pay any attention to it. Instead, you pay attention to breach of promise, okay, and breach of confidentiality and breach of trust. So, if this first writer had shared the script with the producer and said that the document that was shared with you was shared in confidence, it contains proprietary materials authored by me and should not be shared with third parties without my knowledge or consent. If you merely wrote those lines in your document that you've shared, and if you share it over email as opposed to going to their office and dropping off a physical copy, which is untraceable.
There's a thread, there's an email.
There's a paper trail. Because then what happens is, then when I walk in court, the first question that the judge will ask me is, do you have any proof that you had given this script to them? And I will say, yes, this is the proof. Until I shared the script, he didn't want to make this movie. Now that I've shared the script, suddenly he wants to make the movie. And this is a breach of promise. Then I can apply a different test. Then rather than applying the test of copyright infringement, I can tell the court to apply the test of breach of confidence and say that when I have shared this with him in confidence, if he has gone and misused my intellectual property, now that's something that the man deserves to be injuncted for. He deserves an injunction against him to stop him from releasing this.
Right. No, that's super helpful because, I was going to ask you this question. There are so many writers who have this exact concern, right? That when they send their screenplays or their pitches, like whether it's movie ideas, whether it's book proposals to publishers, and then their question is always, okay, what if they say no to me, but then they turn around and make the exact thing? Or most often it's not the exact thing, and it is inspired by it or whatever, like you said, with a lot of different variations. What is it that they can do? So this is a great point. And this is also why this, it's become important now to sign these NDAs as well, right? Like a lot of whether it's clients, whether it's freelancers, whether it's writers, they're getting into that habit of signing a non-disclosure agreement before they share any of their work, to sort of have that proof saying, hey, look, I had signed this. How effective do you think that is?
It is effective. If as a writer, if you're getting a producer to sign an NDA, that's amazing. I mean, that means you have a lot of clout as a writer. So good for you.
Okay. Producers can also refuse to sign NDAs. I'm just asking, do they do that as common practice?
Of course they will. In fact, the standard practice is for the producers to offer you a document to sign. They will give you a document as a writer saying that you want to submit an idea to me. You are aware that I may have similar ideas in development, and that if I go and develop those other ideas in development, you should not come and catch my neck saying I've copied your idea. They make
the opposite of almost like for them that leeway to go and say, okay, I'm working on multiple ideas.
Correct.
It's not about your idea.
Correct.
So at what point can, like from your experience, has it ever been a scenario where someone, there are two works which have this issue of copyright infringement, and the things that are copied are literally word for word? Like, has there ever been a case that you have come across where it's not just certain tropes or certain specific details that are copied, but there are entire paragraphs or entire chapters that are verbatim copied, which, I'm assuming would make your case super easy as well?
It's happened. In fact, this was one of my early cases where I was very passionately arguing on behalf of this writer to get him an injunction against a fairly large producer who had made I mean, this was kind of a blockbuster kind of film. I mean, For obvious reasons, I can't name it, but it was a big film, a well-known film with well-known director and producer. And I had made a chart saying, look at all the elements in my screenplay. Look at all the elements in your film. They are absolutely identical. And in fact, they are so unique that it is impossible that another mind independently came up with these same 20, 30 choices at this stage. That not only the milieu and the setting and the character, but also the flow and the twist and the climax and everything and the side characters. I mean, this would be a remarkable coincidence if it happened. And obviously that's not something one could believe. And we had some proof of communication with the producer. That this writer had communicated with the producer. So we had a pretty strong case. And when it looked like the judge was going to give an injunction, the producer's lawyer said, Lordship will just keep the matter back for about half an hour. We will try and work it out. We'll offer him a settlement. We'll try and work it out so that, no adverse orders are passed. So then we stepped out, agreed on a number, went back into court and withdrew the case. The producer's brother, who was in court, came up to me and he said, Sir, ab bura mat maniye, ek baat bataunga aapko. I said, sure. He's like, see, we got off cheap in this settlement, but you tell your actor also to be careful. So I said, why? What do you mean got off cheap? Because you paid my fellow a pretty handsome amount and he's also very happy. So he's like, nahi, kya hai, sir? Ye na actually European film hai. ये आपके क्लाइंट ने भी कॉपी की है, मेरे क्लाइंट ने भी कॉपी की है, लेकिन ये डिफेंस आई कांट प्रेजेंट इन कोर्ट बिकॉज़ इफ आई प्रेजेंट दिस डिफेंस कि आपके क्लाइंट भी चोर है, मैं भी चोर हूं, then that big production company will come catch my neck. So that's why the settlement is a good thing. So things like this happen.
That's so funny though. No, that's great. That's a great story. But how often do cases like that come to court, in the sense that how often do writers who realize that their copyright has been infringed, or someone has created something that's very similar to the ideas they discussed, how often do they actually decide to take the legal sort of course? What other options are there for them? Like, do they have to sort of go and fight it in court? Can they do something else?
So fighting in court, especially in the High Court, is expensive. It's not something that every writer has either the ability to or the inclination to do, frankly, because it's not as if success is guaranteed. So you don't want to, spend a lot of money on something that's not a sure thing. Which is why in a lot of those cases, the writers will go to the dispute settlement committee of the Screenwriters Association. And you will, they have a whole system of submitting a complaint, and the body will analyze it and will present a report. And so many times what happens is, if the dispute settlement committee gives a decision in your favor, in the favor of the writer, saying that yes, your work has been copied, then that writer can approach the High Court and present this report to the High Court and say that the expert body, which is part of my trade and industry, has evaluated both these scripts, has evaluated my allegations and found in my favor. So therefore that has to, and that is something that carries a lot of weight in the court. So, but then in that instance, typically it is too late to try and fight for an injunction to stop the release of the movie. So then that is something that becomes a suit for damages. So whichever writers do this, my advice to them is that keep aside a set of money for those lawyers, let that fight go on and move on with your life. Don't make this litigation your life. Think of it as an investment, and it will grow one day and maybe give you a bonanza someday. Because I know so many people who, after fighting for years, then get a payout. That also happens.
Yeah.
But you shouldn't sort of put your life on hold and say, now I'm not a writer, now I'm a litigant, and make that your life. That is terrible.
Yeah, no, that's great advice. You were also working for a while with the Screenwriters Association on these kinds of disputes, right?
Yeah, I was advising.
Yeah, can you give me a couple of stories or anecdotes of what kind of disputes were coming to the association?
It would be disputes where a writer, for example, has been engaged by a producer to write a thing, and then halfway through gets fired. And the question is, what is his due in terms of credit? What is his due in terms of money now that he's been fired halfway through? So that's something that the dispute settlement committee would evaluate. Sometimes it would be outright cases of infringement, where, or like the example that you gave, where a writer feels that I gave an idea to a producer and now he's making it without me. And the third would be a category of cases that mostly, in my view, are without merit, where a writer sees a movie that's been released, or this trailer has come out, and he'll say, wait a minute, this looks like exactly something I have in my drawer. And then he'll open his drawer and he'll find something and say, hey, you've copied this, you've copied this. Those are typically not, they don't have much merit, those cases, in my experience.
Yeah. And it's very interesting because actually, I don't think there is a body like that for books, the way that this association works to sort of solve these disputes. These kind of disputes, there's, I think, no sort of industry association as a whole that brings everything together, that can resolve these kind of disputes within the publishing world, So it's, I think what this conversation is also stressing is how important that kind of some sort of governance system is within that industry, to look at, to make also writers feel in a way like there will be a forum for them to be heard. Because again, right, like you said, going, actually filing a case in court is very expensive already, compared to even screenwriters. Book writers don't really make that much money, even if the book is out, right? Sort of the royalties that they get, the advances that they get are not that high. So them trying to fight for that book or for copyright infringement for something like that in court is just another thing altogether. Have you ever come across a scenario, whether with the Screenwriters Association or with the legal cases that you do, where say a book is out, right? Like, so a book is published, and then the author of the book is seeing that in another format, say on film, there seems to be very heavy copyright infringement. But in different formats.
That Aishwarya, that doesn't happen so much actually, because what happens once a work is published as a book, it's probably like the highest level of protection available to you, which is why in the South a lot of screenwriters publish their works as books first, where so that nobody can dispute whether I gave it to you, whether I actually wrote it or not, because here is a book with my name on it. So anytime something like this happens, also you have to understand, once there's a book out, there's somebody vastly more powerful than the writer who gets to sit at the table, and that is the publisher.
Yeah.
So if some producer tries to steal a publisher's book, that publisher is not going to sit quiet.
Yeah.
Right. He's going to want his piece of the pie. So now, and so which is why that happens very rarely, because producers might willingly stomp over an unknown writer. They're not going to stomp over Penguin Random House.
That is very true. What if it's an indie publisher, though, that themselves don't have money? And it's like a local publisher, local book. Or, for example, say the book was published in, the book was written in Kannada, right? And then the movie is in Hindi. In a way where there is a chance, however small or big, that they will not even see the movie or will not even realize that there are these similarities or there has been copyright.
I think this is the kind of thing that used to happen earlier, but now that information flows so quickly, any producer would think 10 times before copying even a regional language book. Because proving the case against you is so easy. Once an earlier work has been published and it's in public domain, then defending those similarities is next to impossible. Assuming the similarities reach that threshold, it becomes very, very difficult to sort of just talk it off and say, no, I came up with the same idea. So I've not seen that happen. And also the other thing is that it's not that expensive to option books. So
so they can just do it the proper way and just option
just do it the proper way. It'll be a few lakhs, and your budget of your film is over 10-15 crores even for a small film. So you might as well just do it.
So this is a very measly amount compared to the full film budget, so they might as well option.
Correct.
Okay, that makes a lot of sense. And in terms of the law itself, how creator friendly is the law as a whole? Is it sort of leaning towards creators? Because the fact that the threshold is so high, is that something in your opinion is a good thing, is a bad thing? Like, how does it play out for creators who are very concerned and anxious about
Yeah.
their work constantly being copied or
So
plagiarized?
the threshold being high is not something that's unique to India. Copyright law is universal. There are international conventions that have been ratified by all countries. So copyright law kind of looks the same in all countries. So the threshold that we follow, the threshold that the whole world follows. So we are not overly friendly or unfriendly. But what we have done is we have had some recent amendments that were championed by people like Mr. Javed Akhtar and Mr. Anjum Rajabali through Parliament, where they ensured a few things that till now were not guaranteed. Number one,
Like what?
royalty will always be given to the author of a work, irrespective of a clause in the agreement that may say that there's no royalty payable. So even if you have a clause that says that whatever I paid the writer is everything and he will get no royalties after this, the courts will read it as if there is no such clause.
Okay.
Right? So that is
that's a very powerful, very important sort of change. I didn't even realize there were author contracts that say that, have a clause like that saying that there is no more royalties payable. The advance is basically all that they get.
They'll do it because I mean it all depends on what kind of a contract you draft. No, so many times writers of original work will get the contract of the writer of an ad agency. So if I'll give you an example. If I have a contract that I sign with the writers who work in my ad agency, obviously that contract will say that whatever creative output you give does not belong to you, it belongs to the client, right?
Correct.
So if I'm on an assignment for Pepsi and I write "Ye Dil Mange More," I don't own that line.
The writer doesn't own it.
Right. And Pepsi owns it from the get-go in this example. So we see a lot of these exploitative contracts where this kind of a contract would be placed in front of a writer who's creating original work. And
anything you write, anything you create is owned by the client or the company, and you have no rights.
You have no rights. So the amendments to the law now fix those kind of situations. The other thing that it fixes is with an assignment. So if I've created a work and I assign the rights in it to you, an assignment is basically a complete wholesale transfer in perpetuity of all my rights in it. Okay. So if I write a screenplay, I have to assign it to my producer, and that's what gives my producer the right to go and turn it into a movie.
Okay.
Section 19(4), which was introduced in the Copyright Act, says that unless otherwise specified, the person to whom I'm giving my assignment of my work has to utilize it within a period of 1 year, or else it comes back to me.
Okay. So effectively, it's not that after you assign it to me, I'll just shelve it and then I'll just never use it again, and you don't own the rights either, and I don't do anything with it either, and it just never sees the light of the day.
That's exactly right. Then, but however, there's something you should know, that this provision or this protection is something that you can contract out of. So you can say that I know that this section protects me, but between us, I'm willing to give that up. Unlike royalty, which can't be given up, this thing can be given up. But then what it does is it allows the writers to have some bargaining power and tell the producer ki theek hai sir, 1 saal may be too short, but aap bolo kitna? 3 saal? 5 saal?
Okay, so like you gave the example of the royalties clause that some sort of contracts have. Can you tell me any other things, specific clauses or specific wordings or verbiage in contracts that writers should kind of, be aware of or look for as red flags?
Okay. The biggest red flag I would say is the words "work for hire." If you are the author of a creative work that is original to you and you're handing over completed or mostly completed work to a publisher. And if you see those words, work for hire, that means the producer is trying to con you. He's trying to pull a fast one on you.
Okay.
Because
what does work for hire mean?
What is work for hire? The copywriter I described who came up with this Ye Dil Mange More, he's a work for hire. Okay. So he's somebody who is providing his creative services for a fee.
Right. Almost like a salaried or a contracted, like employee, exactly right. Sort of.
Yeah. And the term of art in our profession is a contract of service versus a contract for services. Okay. A contract for services is what a writer in an ad agency does. He has a contract under which he provides services. Okay. A contract of service is different. A contract of service is when I own the work and I'm just giving it to you. I own a document, a manuscript, and I am giving it to you under an assignment. So I never worked for you. I was never your employee. If you can't fire me, right? It's like, think of it as the same thing as buying a physical piece of property, right? Like it's like walking into an Apple store, buying a phone, walking out with it. And then when Apple asks you to pay them money, you say, money, go to hell. You're fired. I didn't like your service the way you did it. And they're like, but you have the phone. You can't walk out with the phone and tell me I'm fired. So that's what a contract of assignment is. I used to have it. Now you have it. Therefore, give me the money. If you don't give me the money, you don't have it. You got to give it back. As simple as that. But if you see work for hire, it means, so those are contracts where, and this we see quite commonly, less so now because there's a minimum basic contract that we've drafted with the help of the Screenwriters Association. You can go to their website and download it, and you can see the kind of the clauses that you should have in your contract. So it happens less now, but earlier it was very common for a producer to meet a writer, like an idea that the writer has given, read the whole script, like the whole script, and then give a contract that says, I, as the producer, had an idea that why not make a movie like this? I came to know that you are a writer. You told me that you'd be very happy to write my idea. Therefore, I'm giving you a salary. Now go write my idea.
Right.
Now, if this writer signs such an agreement, despite knowing fully well that all the recitals are lies, then this writer is his own worst enemy. Nobody can help him. Because he has put a signature to a document that is false, and then no court can help him. So the solution is don't sign something that's not true.
That's a good one. Anything else other like work for hire? Any other words or red flags that writers should look for?
I think the work for hire is really the most important one, because what that does is, if you see that word, it will mean that you will see 10 other clauses that follow logically from that, and all those 10 are wrong. For example, if you see a work for hire, you will see a termination clause that says you can be fired and the script will belong to the producer. Right. You will see that you can be fired and then the movie may be made and your name will never be put on it. So all those illogical, exploitative clauses are downstream of work for hire. Whereas if you go into the other category of contract, which is a contract of assignment, then all those follow-on clauses will generally be absent, right? It's a different category. So, I mean, beyond that, now these people should really consult a lawyer to see what exactly is changed. But this is the red flag. The words work for hire, the contract services, the termination where you can no longer be recognized as a writer. You know, those are the red flags.
No, those are very important sort of red flags to know. I think, that's why I was kind of asking you, because for a lot of writers, they kind of don't know where to even start getting advice from a lawyer, what kind of even basic things to start looking for, or what kind of red flags exist. So this can be a starting point for them to think about even the fact that when someone sends them a contract, they need to look for red flags, or they need to see and actually search, is this contract fair to me? Correct. I think that question of fairness, right? Unless that comes to them from within saying, I need to think about, is this fair for me? Is this, compensating me for actually the amount of work I'm doing. We will get a lot of writers, exactly like you mentioned, who will end up signing that exploitative contract.
Yeah.
And then there is nothing that can be done if they realize later, right?
Yeah. No, but now I don't think any person who's literate enough to be a writer, savvy enough to find producers, has really any excuse if he doesn't do his due diligence on the contract. The Screenwriters Association is a union which provides incredible services for writers, and they have an in-house lawyer who is there to vet contracts for you. They have a model contract on their website. They have the thing I told you earlier about what you should send on emails to protect yourself. Yeah. This is shared in confidence. Those words are there on the website. So you can go there, literally copy paste it and make it the footer of your every email. So right. If you don't do these steps, then that's on you, at this point.
No, but I also mean for, book writers or other kinds of writers or creators who don't have that kind of support, specifically that the Screenwriters Association is giving.
Sorry, I mean, I'm sorry if I come across as too harsh in this, but I'll tell you where it's coming from. After now 14 years of being a lawyer, I'm frankly, and knowing a lot of writers as close personal friends, I am a little bit now tired of these arguments ki bhai, I'm to an artist. You're not. If you're an artist, you be an artist. You be a businessman, right? You have a valuable product. You please think of yourself as a businessman, and that's when somebody will deal with you that way. If you think of yourself as this artist, then you will be treated that way,
Yeah, no, I 100% agree. There's this whole discourse about, artists or writers, it's like, they are lost in their own world and they're introverts and they can only do art and they can't think of anything else, or they shouldn't. Even like from, I don't know, centuries ago, artists have always, other than literally cave paintings, artists have always created art for money, right? Like whether it's even these big painters, whatever, they had patrons, right? They had people who were paying them, and they were clearly providing services for money.
That was a feudal times. Those were feudal times. Now we are living in a modern in a modern democracy with rule of law. You don't need to be like this. Have you heard of Script Notes, the podcast of Craig Mazin?
No.
I would highly recommend everybody. I mean, firstly, they talk a lot about writing, which is great. Craig Mazin is the guy who created Last of Us, which is on HBO right now. He created Sherlock. So he's basically a phenomenal writer, and he is a champion of workers' rights. And on that podcast, they keep talking about that. He's the one who leads them on strikes. He's the one who negotiates with the producers. So don't tell me you can't be an artist and a businessman and a champion. You can be that. And in the West, if you're trying to be the best, there are examples of people who are like that.
Yeah, definitely. That marks the end of another episode of The Book People. Tune in every Thursday for some breakdowns, some truth bombs, and some insightful and real conversations with industry experts about all things books. This podcast is created by Bound. We work with writers and brands to create content across formats, whether it's books, podcasts, newsletters, or screenplays. So get in touch to see how we can help you grow through stories. And follow us at Bound India on all social media platforms. I'm your host, Aishwarya Javalgekar. You can follow me on LinkedIn, where I share many more insights about books and content. Or you can get in touch with me at aishwarya@boundindia.com if you have any suggestions on topics I should cover, or if you want to book any of my services or consultation calls. Until then, keep writing.